Matters. Welcome once again. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this long-running program continues to provide legal information, relevant examples, anecdotes, practical assistance to help you with law matters because the law matters. A better understanding of the law puts you in a better position to protect yourself, your family, and your business. As we present various topics, you may, of course, decide to handle some issues yourself. You'll be better prepared, so will the counsel you select. Our goal always is to help you to save time, money, and achieve the best possible results. And we want to, as always, welcome again and thank Attorney David Bizarre from the Bizarre & Associates law firm in East Providence, who continues to weigh in on the topics that we discuss. And this week, adult guardianship. Who makes the major decisions that involve your loved ones when they can't do so for themselves? So if the person you care for is in good health, you may not be thinking about what possible need you'd have for a conservatorship or a legal guardianship. But consider the circumstances that might occur when they can't make decisions for themselves. Perhaps it's Alzheimer's or some other form of dementia or a stroke or an incident or an accident or some general cognitive decline. Numerous things can happen, some serious medical condition. And as we've spoken about it before, perhaps you may have someone who has a healthcare directive, as we've spoken about it, a power of attorney, maybe for finances. We've covered those topics. Maybe they have one or none of those topics, or maybe even there are other important decisions that have not been covered in those documents. Or what happens if you have a special needs 18-year-old who now becomes an adult? What are their options? Is it complete guardianship? Is there some supported decision-making option that gives only limited restrictions? So what do you need to know about doing this, and how does it happen? Heads up, I guess the thought is that this is not a simple process. It's probably not one we can easily say is a DIY, do-it-yourself. So let's begin, David. Let's begin to cover these terms.
Sure.
So there's a word called conservatorship, as well as legal guardianship, adult guardianship. Same, different, used interchangeably?
They are used interchangeably. They're not exactly the same thing. Usually, guardianship people think of in terms of making decisions for somebody that can't make decisions for themselves. People sometimes think of conservatorship, of conserving the assets that the person has, but it can fall under a guardianship. So if you have a petition for guardianship in Rhode Island, it particularly asks you, well, what kind of decision-making help does the person need? Is it over medical decisions? Is it over residence, where I'm going to live, association, who I'm going to associate with, finances, and that type of thing. So if it's a complete and full guardianship over all of those issues, it really covers what would be otherwise perhaps covered in a conservatorship.
So while we're going to talk about who needs one, how, and why, what are some of the pros and cons of having such a thing in place, such an instrument in place?
Okay. So before we get to filing the guardianship, someone comes to me, and oftentimes they come for a will or a trust. But what they're really coming for is an estate plan. And a complete estate plan covers not only what's going to happen if I die, but what's going to happen if I live and I become unable to make my own decisions. That's where you're trying to avoid having to go to probate court and have a guardian appointed for you. You want to try to put documents in place that allow you to decide who's going to make decisions for you. So when we do a trust plan, for example, the trust plan will also include power of attorney for financial decisions. It is a complete, robust power of attorney that gives the person authority to do just about anything that could come up if you're either unable or unwilling to make those decisions yourself. We also include the healthcare power of attorney. And again, we try to make it as complete as possible with your wishes included in it, but telling the loved one who's going to make the decision for you, these are what I want done if I reach these certain types of situations in my life, including withdraw respirators if that's what's keeping me alive and I have no life. Do not intubate me if that's, if I haven't been intubated yet. Do not resuscitate me if there's no chance of recovery. And medicine isn't black and white, it's gray. So I like using durable powers of attorney for healthcare, or in Massachusetts, healthcare proxies, because someone should get all the information and make a decision. It shouldn't be like a checklist, as far as I'm concerned. And one of the other documents we use when we create a trust plan is a nomination of guardians. This is who I want to be my guardian if I ever end up in that situation, and all of the paperwork and things that I've put in place aren't enough, and we're still going to need a guardianship. This is who I want, and maybe a backup to that person.
So we've discussed wills and estates before. In just preparing for this particular segment alone, it was very clear that it's cumbersome and there's a lot of filing and paperwork, and quite possibly it might be less expensive and less cumbersome if someone had the will and estate in place and that was part of it, rather than have to go through this process. Although with this process, it might be somebody petitioning for someone else rather than your client taking the initiative to handle all of these affairs himself. Care to comment on that?
You're correct. It's much better to put things in place yourself if you're able to. But you had mentioned earlier on about the special needs child who was a child and now is going to become an adult and can't really make their own decisions and wasn't able to do documents to do that planning, because that's the whole point of needing to do the guardianship at age 18 when they become an adult. As a child, of course, the parent is the natural guardian and is able to make all the decisions and care for the child and make sure the child's best interests are looked out for. But now the child's an adult and you don't have that ability anymore, and they don't have the ability, so you have to file a guardianship. And you talk about the cumbersome nature of a guardianship. The problem is if there's assets or income that are coming into the child, and so now you need a guardianship to make decisions of where the residence is going to be, what medical care the child's going to be, and whatever money might be coming in on behalf of the child, how that's going to be used for the child who's now an adult. So the problem with guardianships are, among other things, you have to file an annual report, or if you're lucky, maybe a biannual report of here's what's come in, here's what was used for, and here's what's went out. It's an accounting. And I just recently went and did the 14th accounting for a guardianship. So it's an ongoing obligation of the guardian.
So with a special needs child who becomes an adult, there's always interest now in what they call supported decision making. So if the young person is able to maybe live by himself with some supports in place, or maybe can handle some of his finances but really needs to have just someone to look out and make sure that he's not being taken advantage of, or some assistance. There's an emphasis on having independence, limited restrictions if it's possible. When it comes to an adult who's always taking care of himself or herself, and then suddenly they are gradually losing their ability to do one or the other, how does the instrument work so that we know when to intercept, when they should stop doing all of their finances or just have someone oversee them? How does that play out for an adult who's been fully on his own with a trust or with an estate planned?
So in recent years, courts, probate courts, have tried to make sure that there's the least amount of restriction placed on the ward, the person who's under guardianship, as you can, and safeguard their lives. So if they're able to decide where they're going to live and who they're going to associate with, then don't put a guardian over those decisions. Let them make those decisions. But if it's finances that you're worried about, then limit it to just a financial power of attorney. And that's the whole goal of the probate court these days, is to put in safeguards and keep people safe from predators or whatever else it might be, without taking away their dignity and their control over their own lives as much as you can. And I've had cases where we've gone in and the ward has said, you know, I can do this and I can do that. And the judge says, yeah, you can. And we're not going to take that away from you, but you really need help with this. Yeah, they'll admit at that point, well, they know they have some control over their life. I do need help with that. And there's always, usually a guardian ad litem appointed to talk to the ward and all the people involved to make sure that the ward's best decision, the best decisions made for the ward on what kind of help they need.
And does that continue on so that maybe the need is perhaps temporary, or maybe it's in continuous and perhaps a staggered decline? Is someone always monitoring that to make sure that the person has the maximum amount of independence and self-agency?
Yes. And every year there's an annual status report that's filed to say whether there's been any change. Has the condition that the ward might be suffering from gotten better? And if that's the case, maybe less intrusive guardianship needs are being covered. Or has the ward gotten worse and perhaps there are more? So you file the annual status report to let the court know what the situation is and whether anything has changed.
So what happens when, even if the person has a will, an estate, a plan in place, but a child, an adult child, decides, I don't think that's really working? Is that when someone might begin the process to petition to interrupt that, to change that, to, I don't want to say usurp the power, but to take control over it? How does that play out, David?
Yeah, the documents that are in place may not be sufficient, or even if they are sufficient, there may be some children or beneficiaries or descendants at odds over what the appropriate care is, and they don't like, maybe one of them doesn't like the person who was put in charge and what they're doing for decision making. So at some point in time, one or more of those heirs at law, people of concern, may file for a guardianship to say, hey, we need somebody else to overlook what decisions are being made and maybe look at who's making those decisions.
So they would file, so let's start what that process is. If they wanted to challenge the legal document that's in place or just challenge some portion of it, how does that play out, David?
So you file a petition for guardianship. And when you file the petition for guardianship in Rhode Island, there's forms that you check off, or boxes that say, do you have this document? Do you have this document? Do you have this document? And if you have all those documents, perhaps why then do we need a guardianship? And you maybe address some of those issues. And of course, when you get to probate court, you address the issues. So the process is, in Rhode Island, you start with what's called a DMAT, a decision-making assessment tool. And that's filled out usually by a doctor or some medical provider that gives the court some insight into why a guardianship is necessary in the first place. What capacity, what function does the person who is the proposed ward, the person who's going to be put under the guardianship, what capacity do they have? And let's look at what an independent medical provider might say that capacity is and what help that person thinks the ward needs. Then you have a petition for probate. And a notice that has to be filed to not only the ward, that should be served in hand to the ward in advance so that they know that this hearing is coming, but also to whatever other beneficiaries or heirs at law there might be, so that they know that someone's filed a guardianship for a loved one.
So if one child is petitioning to be that guardian and he or she has siblings, they all need to be on notice.
Correct.
With some record, whether it's newspaper, email, or apparently they must make a very concerted and well-documented effort to have notified everyone who's possibly involved or likely to be a beneficiary or whatever.
Yes, there's a notice that needs to be served either by mail, usually, on every known heir at law, so every sibling. And the siblings are entitled to come to court and say, yeah, this is an appropriate person to care for mom or dad, or no, we should have somebody else, or maybe we should have co-guardians.
And at that point, if there is going to be a hearing after there's a petition, Yes, those who object, who might want dibs or the responsibility, depending on how you want to look at it, is that the time when a judge would also talk to the person who's likely to be the protected person, the elder or whatever, to see if in fact any of this is viable? Will that judge be the person to make a decision, or will he also call in the accountant, the doctor, or other professionals?
So first of all, the court in Rhode Island is going to send out the guardian ad litem, a lawyer usually, to speak to the proposed ward, to speak to the other interested people, siblings of the ward's children, or perhaps the ward's siblings too, if they have them, and they might be interested, and they may have a different idea. But what the goal of the judge is, after listening to what the guardian ad litem has to say, is perhaps I've got enough information to make a decision and everybody can agree, or maybe we don't, and we have to have a hearing so that this child can present information as to why they would be best suited, or that child, or a sibling of the ward, if there's brothers and sisters of the proposed ward, can put in information, or whoever is interested in deciding who should make decisions for this person.
So while the goal, or the pro or the positive side reasoning for having a conservatorship means that, say it's an adult child who has full cognitive abilities, will take care of the person who isn't, the other side of that is what happens when there seems to be the thing that you're trying to prevent, namely elder abuse of some kind, financial on the one level, or maybe on the living circumstance or environment on the other. What happens then to that tool or instrument that's in place?
So if a guardianship's put in place, that overrides whatever other instruments may be in place. If the court says, well, we need somebody appointed as a guardian to make, for instance, healthcare decisions. Now, if you're appointed as the guardian to make healthcare decisions, even if there's a document that gives that power to someone else, the court has given it to a guardian to make those decisions. So if you went to a doctor and they said, look, I got healthcare power of attorney, and the guardian came in, well, here's my appointment as guardian, which is dated after that, I would, as the doctor, advise listen to the guardian, because they've been appointed by a court and given that power to make those decisions, for example.
So how long does this process take when you are starting the paperwork? And we understood, or I mentioned in the beginning of the segment, that this can be a complicated process. You started to list some of the documents and that there are many. How long might this process take? So how long do you have to plan ahead to make these things function properly?
You file the petition for probate with the probate court. They give you the court date and notice that needs to go out to all of the heirs. You file all of that. You have to serve the ward more than 14 days in advance of the court date, so you have that time frame. They also have to have time for the guardian ad litem to go out and speak to the proposed ward and any other interested people that need to be spoken to. And you also, as the proposed guardian, need to go to the Attorney General's office and have fingerprints taken and a background check done to make sure that there's no criminal reason why you're not appropriate to be the guardian. So there's a period of time. I would suggest that at least probably a month from the time you start to you get to court. Now you get to court and there's a dispute. The judge needs to determine whether or not I need to have a hearing to make a decision on this case and let everyone have a right to a trial, or if it's something that can be just done by agreement or otherwise.
So if you, as a lawyer, work on someone's behalf, apart from meandering through all of this paperwork and filings, do you end up expediting? Obviously, you have to charge for it. Yes, there's some cost to it, but can you fast forward it? Can you expedite it? Do you take care of those background checks any more efficiently than a person acting on his own behalf might?
We make sure that the petitioner, whoever it might be, your client, knows exactly what they have to do and get done what they have to do. We make sure the paperwork is done correctly so you don't start and stop and say, oh, wait, I got to start all over again. And more importantly, we advise the client and usher them or shepherd them through all of what the judge needs to hear, so that the judge has enough information to be able to make a decision in a timely fashion. Is it any quicker? It's only quicker in the sense that everything is done correctly, theoretically, hopefully.
So do you end up being, not judge and jury, but do you end up being the person who, at least initially, vets the proposed conservator? Are you
Or
likely to
guardian.
say,
Yeah.
are you likely to say, why do you want to be the power of attorney for finances? What qualifications? Do you go through a pre-screening? And do you need to be able to say, I know you have the interest, do you have the acumen? Do you go through those things?
I don't know if all lawyers do that, but when a client comes to me, I go through that and I will counsel them on to whether or not they're doing whatever it is for the right reason in the right way, and look at all the circumstances, who else might be involved. And I'll advise my client, perhaps, you would be good to do this part of it, but maybe that person would be good to do another aspect of it. And you can ask the court to appoint co-guardians to do different types of things. Maybe one's doing finance and the other's doing health and association or residence and that type of thing. And all in all, it's a little bit like child custody for me. I do have a client to represent, and I have to represent, my client zealously, but I also want to advise my client what's in the best interest in custody for that child. Well, what's in the best interest of mom or dad or whoever the proposed ward might be?
And I assume that part of this, and perhaps you can share some of it now, what are they getting into? So if someone says that they want to be responsible for the person's care, say in the home or maybe in another home, do you go through the listing of the kinds of things that are going to be expected of them if they become a conservator, what their responsibilities are? You mentioned the paperwork that there might be for some accountability, financial accountability, but even in terms of the routine care, the daily care that needs to happen, do you go through, to the extent that you can, obviously you're not the MD on the case, but you have a list of things that you can share with them so that they are better prepared before they sign on, literally?
Well, we do go through that, but I also try to get to the motivation as to what is it you're trying to do and why are you trying to do it, and is this in your mom or dad's best interest, and is it what they would want? And so we talk about it not only from what is your responsibilities, but what are the goals and why are we trying to do this?
Which leads me to ask, do conservators get paid if they're the family versus if a judge appoints a third party? How does that work?
It's totally up to the judge to decide what's appropriate and in what amount would be appropriate. So one of the things when we talk about fees and costs and that type of thing is there's always, when there's guardianship, oversight from the probate court judge to determine what's appropriate.
So what happens if someone does mishandle their responsibility, whether it's on the personal care level or the financial level?
So breaching a fiduciary responsibility, which it is.
Meaning the finances?
Both.
Both, okay.
You have a fiduciary responsibility to provide the best care you can for the board.
Okay.
But also, especially financially, that's easier to measure and understand. There can be both, first of all, you can be removed by the judge. So if you're not providing the best care or doing what is needed for the ward, the judge can say, you're not able to do this, I'm removing you. If you're stealing money from the ward, the judge not only can remove you, but you can be referred for criminal investigation.
And if the person who's being protected challenges it, maybe because they have some mental issues or cognitive issues themselves, or maybe they have some very serious concerns about how either funds are being allocated or suggested care facilities are being selected, what rights do they have and how do they execute those?
They can be heard by the judge, and the judge will
Directly?
Listen. Directly, sure. They have a right to go to the court and, in fact, insist on being brought to court if they're unable physically to get themselves there, and tell the judge their concerns. And the judges are they'll listen, but they'll also understand if there is a mental capacity issue and what they're saying doesn't make sense, well, then they'll listen politely, but they'll make their own decisions based on what they think is right.
So you referred several times to this being done in probate court. We talk about probate court when someone has passed and how their goods are being divvied up. Does all of this start and finish in probate court, or is it a family issue?
Well, in Massachusetts, family court is probate court.
Okay.
In Rhode Island, probate court is probate court, and probate court has the power to hear guardianships for adults. Family court hears guardianships for children in Rhode Island. They're two separate courts.
So someone under 18, if they were having an issue, if they wanted to be severed from their guardian or whatever.
Somebody petitioned for a guardian because perhaps the parents have passed, for example. Those guardianships. You can hear there's actually a concurrent jurisdiction in probate court and family court for guardianships for children, but if it's contested, it's going to family court.
How does a conservatorship end? When does it end? I mean, apart from death, when does it likely end?
A guardianship or conservatorship will always end at death, although there may be some issues that need to be resolved even after death by the guardian, but that you're appointed as a guardian over a living person, so when the person's no longer alive, the guardianship sort of ends, except for maybe some accounting or other things that need to be done for the court. It can also end if the ward was suffering from something that they recovered from. And so the court can say the need for the guardianship is no longer in place. For example, actually, if you're a guardian over a child who doesn't have disabilities and the child now is 18 or whatever the age of majority is in a particular state, but 18, the guardianship would end because you're no longer a minor.
So you mentioned that there are reporting requirements, presumably on the personal care side and the financial care side, and if it's happening biannually, whatever the routine is. If the situation changes in the middle of those reporting periods at any time along the continuum, can either party, either the person who is the guardian or the person who is being protected, can they raise their hand? Can they come to a lawyer and say, we need to have this revisited now because I am currently in a different status, or I need to change some facet of this? Is that always up for review?
Sure. Yes. If there's a change of circumstances, you can always file something with the court to have them take a look at it. For example, suppose somebody was appointed guardian for a child who has parents, but the parents were unable to care for the child, but now they're back on the scene and they say, we don't want this guardianship anymore, we want to take our children back. They're entitled to be heard. You don't have to wait for the annual report to do that, for example.
And if there, just in the brief amount of time we have left, if there is a question the protected person just wants to question some facet of what they're doing, does that require a complete review in front of the judge all over again, or is that something that usually can remain between, say, the respective lawyers of the two parties?
You want to bring it back to the judge, because if there's a court order saying that this, that, or the other thing it needs to be done, you can bring it back to the judge and say, hey, we've agreed to change this, but the judge has to order the change.
Good to know. We hope that this has been helpful to you in terms of caring for your loved one. Please do stay tuned to The Law Matters. As we say, the law matters to you. Thank you for tuning in.